Okay, recording in progress. Yes, again, good evening to everyone who joined the Defending Digital Privacy Network from Malaysia, the Philippines, Indonesia, and Thailand. And good morning to Elizabeth, the Program Director for Global Program from ABA Rory, and David Husband, who is our speaker today, who live across the different part of the world, super early right now. And today we have nearly 80 people joining us. Thank you very much for your time. I mean, registered, but right now we have, about almost 30 people, I believe. My name is Jum Suphapon Darak, a program consultant now for Human Rights Lawyer Association, HRLA. We are glad to be part of this program to provide and facilitate the knowledge to DDP network, because we understand that how important of defending digital privacy for our region as well. HRLA collaborate with American Bar Association, Rule of Law Initiative. We organize virtual seminar series for our network in Southeast Asia. And the seminar will be like kind of short and only 1 hour for you all to be able to participate and join in the evening like this. It's only 1 hour. And today is the second event. And the next one will be on the 29th of November. And if you want to see who, you can go to the chat box. Our staff will put that link in the chat box. And for today, 1 hour, we will have Q&A session at the end. So please feel free to write your question in the chat box, or if you would like to speak, please click the button to speak. We will make sure that you have time to express your question. And next, I would like to give this floor to Elizabeth. She will give you more details about this session and also introduce you to the speaker. Elizabeth.
Hi, thank you, Jum, and good morning, everybody. It's wonderful to see this next session happening for the DDP network. As many of you know, this project is intended to help lawyers and people interested in digital privacy to really hone in their skills on this emerging area of law and help shape the policies within their own jurisdictions in a manner that sort of best suits your culture as well as your community needs. As Joe mentioned, this is the second of a series of virtual seminars intended to address any technical issues that you may have questions about, so that you stay abreast of emerging elements in this area of the law. So please do let us know if there are other topics that you are interested in hearing about, and we can find speakers for them. We do also encourage you to share your experiences in the chat, because this is a forum for you to get to know one another across borders and share your experiences and learn from one another. With that in mind, I also want to remind everybody on the call that we do have available a fund for traveling to different international conferences related to digital privacy. So if you hear about a conference internationally that you would like to attend to, my colleague Mary will share a link in the chat. Please click on that and check it out, and let us know if you have any questions about that. Now, with that in mind, I'm really excited to introduce today's speaker. It's 5 a.m. my time, and I'm up and ready to learn about the policy process for developing digital privacy law in the United States. Now, this is, of course, a unique jurisdiction, as all jurisdictions have somewhat slight differences in their structure, their setup, and their cultural backgrounds, but the policymaking process can be very similar despite all of these differences. So I'm excited to hear how David explains to us what the different challenges are in developing privacy policy. And hopefully that will inspire us to have a conversation about ways in which to overcome these types of challenges in our own jurisdictions. So with that, I'm going to introduce David and let him take the floor. Far more interesting than me. So honored that David has taken the time to speak with us today. He sits on the Privacy Advisory Group for the Defending Digital Privacy program and has offered critical insights into the development of this project. In addition, he's very busy. He serves as the cybersecurity and privacy attorney for the Federal Reserve Board of Governors for over 9 years, and is also in addition to cybersecurity and privacy, he's a senior counsel in the board's legal division, and he focuses on open data, artificial intelligence, insider threats, cloud computing, contracting, and digital identity, as well as a council member for ABA's Science and Technology section, and is the vice chair of the SciTech e-Privacy Committee, and is a chair of the Law Student Engagement Committee and vice chair of the Homeland Security Committee for SciTech, as well as a fellow for the American Bar Foundation. So he is very integrated into various different levels and organizations related to law and policy here in the United States, and can offer really valuable perspectives on this policy process. With that, I'm going to turn it over to you, David, and look forward to learning.
Great. Well, thank you so much for that warm introduction, and thank you for having me. It's been wonderful to be associated with the project, the Defending Digital Rights Project, over the last year, and I am just very excited to be here. If we can flip to the next slide, I will start rolling. Oh, and before that, okay, so I do need to say this disclaimer. I'm speaking in my capacity with all the aforementioned titles, but not my government one. While my day job is a senior counsel at the legal division for the Board of Governors, I am not here speaking in any government capacity, and any views expressed here do not represent the views of either the Board of Governors or there we go, the Board of Governors of the United States. So I'm mostly here in my capacity as the vice chair for e-privacy, as well as the privacy advisor. So as long as that's set, we can get started. So next slide, please. So what I wanted to, this is kind of my overall approach. What I'm gonna do today is I'm gonna sort of give an overview of the uniqueness of the U.S. privacy model, which is a sectoral model as opposed to an omnibus international model. We'll talk a little bit about international privacy. We'll look at some of the federal sectoral laws, the state privacy laws, and then I'm going to talk a little bit about the federal privacy legislation that was introduced last year. And then I think the more interesting part of the program is going to be what I've called blockers, which is going to be like, why do we not have a federal privacy law? What's stopping us? And I'll walk through preemption, private right of action, dysfunctional Congress, complexity. We'll have a little bit of discussion about industry and advocacy tensions on how to shape these laws, because I think that actually will be particularly interesting to some of you in the audience. And then finally, like the final emerging blocker, which is as more states, US states pass laws, who needs a federal privacy law? So with that, next slide, please. So as some of you may know, but if you don't, the US actually has sort of I wouldn't say unique model, because I think that this is present, but a sort of a model that's definitely in the minority, which is that it regulates privacy on a sector by sector basis. And unlike sort of like, say, Europe or other places that sort of set up the GDPR and a more overarching privacy construct, the US will focus on individual areas, create a law for that area, often task a specific regulator to that area, and then that will develop its own case law and its own approach. Other factors about the US is, as you may know, is that as a federalist society, we have a society with a lot of federalism baked in. We have action at the federal level, we have action at the state level, we have action at the local level, we've got lobbyists going on. And so to try to capture all that, I wanted to say, you'll see the slides, we're acting at the federal and state level. We also have agency regulation, because the agencies sometimes are empowered to do it, sometimes the state attorney general, sometimes the states themselves, like California has actually set up its own data protection agency. And then, of course, just to make things fun, sometimes we let just ordinary people sue, and then we go to the courts. In terms of like what law governs, its privacy is bound by general constitutional principles. There's both federal and state constitution issues, then just regular federal statutes and laws and regulations, as well as state statutes and regulations. And then finally, there's a body of common law privacy that I'm not going to get into too much, but I didn't want to ignore it, which is sort of like torts, property, and general common law, like principles of privacy, like seclusion and stuff like that. Next slide, please. So I'll start with what's been happening at the state level recently, because I think this is something that we're generally familiar with. So there's always been state laws on privacy, I should be clear, but what's been happening because of the GDPR and the creation of like a more comprehensive omnibus approach, several states were like, we like this. This is great. And the first one out of the gate, as many of you know, was California. In 2018, they passed a law that was going to be effective in 2020. California, being the way it is, was like, well, that was good, but it wasn't great. So they're like, they did it all over again. So there's actually been 2 California privacy laws, and the current one is, I believe, it's the California Privacy Rights Act, although I'd have to, that takes effect this year, and it's been changed. In addition, states such as Colorado, Connecticut, and Florida, Illinois, Utah, and Virginia, which Virginia is where I live, have all passed sort of like privacy laws, and they have distinctions. I will note Florida is sort of special in that they've passed what purports to be a comprehensive state privacy bill, but a lot of privacy professionals actually think because the scope of entities under who would be subject to its jurisdiction is so narrow that it's not actually a comprehensive privacy law. And the other unique one is Illinois, which has BIPA, the Biometric Information Privacy Act, which is a very powerful state sectoral law, but not actually a state comprehensive privacy law. So this year, 2023, if we can flip to the next slide, has been incredibly busy. So 1, 2, 3, 4, 5 states as of like last year. If we can flip to the next slide. Then just in 2023, we've added another 1, 2, 3, 4, 5, 6, 7 additional laws. They're all not effective yet. They're coming in. They usually pass the law, and then they have a little bit of time for the companies to get into compliance. But we went from having 5 over the last sort of 5 years to having an additional 7 just in the last year. And I know that that's been a topic of great interest for U.S. privacy professionals, because that's like more than twice as many laws as there were before. So those, as you can see from the slides, it's Delaware, Indiana, Iowa, Montana, Oregon, Tennessee, and Texas. And the interesting thing about this is there's an incredible amount of regional diversity and political diversity. You see red states, you see blue states, you see on the East Coast, you see in the South, you see in the Midwest. You don't actually really have, and you do have the West Coast with Oregon in there. So we've actually got a ton of geographical and political diversity, which really shows that in some senses you would think that privacy is becoming a bipartisan issue, at least at the state level. Next slide, please. So I'm going to take a step back from the states for a moment and switch over to sort of the federal side. So as I mentioned, the U.S. has the sectoral model where we regulate privacy based on like sort of like what the topic is. And this has been going on at least since 1970. And what I've done is put a list of the various laws that cover various sections. So we don't need to walk through all these, but if you look, you've got credit reporting, the government has its own laws, there's education, financial records, the press has a law that affects their privacy, telecommunications, electronic communication, specifically sort of wiretapping or email, video in this instance. I, as a government attorney, and that's not the capacity I'm speaking in, but in my day job, I often like interact with the Privacy Act of 1974, the E-Government Act of 2002, quite a bit. But you've got laws on credit reporting, which protects how people can deal with your credits, the credit information. You've got FERPA, which protects student records. And all these laws, FERPA, for example, is administered by the Department of Education, whereas the Credit Reporting Act is administered by the Consumer Financial Protection Bureau. So in addition to these you've got different laws, and you've got different agencies that regulate it, and they happened at different times. So you've got a different Congress, because Congress is not a static entity. The Congress of 1970 is not the Congress of 1980, is not the Congress of the 90s, certainly is not the Congress of today. So you see that you see this sort of development. And if we can go to the next slide, you'll see it just didn't end in 1988. We kept going. Next slide, please. Yep. So then we continued onward in the 90s with telemarketing, Driver's Privacy Protection Act, health, which is something I imagine many of you guys know. HIPAA is very, very well known, probably one of our better known ones. And HIPAA later is amended by some acts, and they bring in some genetic information. Identity theft, children. The COPPA is actually quite has been around for quite a while, but the FTC has really been stepping up of its enforcement, and it's been a big topic. I would expect to see potentially an amendment to COPPA in the future. And then finance, you've got the Gramm-Leach-Bliley Act, you've got email spam, you've got the Video Voyeurism Prevention Act, which actually applies only to federal bases. And it's still happening. Judges, there was a judge who basically someone tried to attack the judge and he went to their house and he killed her family. And so Congress passed a special privacy act for judges' PII that just applies to those. And it's called the Daniel Ander Judicial Security and Privacy Act. And it allows the government to basically withhold that PII from all sorts of requests and protect it. And so that's the very latest like sectoral privacy law that's been passed to my knowledge. And so I wanted to give everyone a taste of this. I know this is a lot to take in, but when people say, oh, I'm a privacy expert, I'm always a little skeptical. I'm like, in the US, I'm like, in which sector are you focused on? Because there's a bunch of sectors. And, a lot of people, when push comes to shove, they'll say, oh yeah, I'm a HIPAA lawyer, or I actually am a government privacy lawyer with familiarity for financial privacy laws in particular. So continuing on, I'll go to the next slide. The other fact, so we talked about the laws, and then I want to talk a bit about the entities who enforce the laws. So one that I've already mentioned a few times is the Federal Trade Commission. They're probably the most important actor. They have what's called Section 5 Unfairness or Deceptive Practices Authority, by which they can enforce companies' privacy promises against them. And in fact, to not have privacy promises is itself kind of unreasonable and unfair. And so the FTC is a big actor in this space, particularly for the private sector. So you see a lot of interest and several of those regulatory laws that I talked about are under the FTC's enforcement authority and jurisdiction. There are other entities, though. It's not just the FTC. We forget about it, but the Federal Communications Commission, one of my friends actually went there to just do privacy enforcement recently. They protect customer proprietary network information under the 1934 Communications Act, and they can bring enforcement actions kind of against, cable companies or whatever who are violating that. The other actors that you'll probably be familiar with is state attorney generals. They're kind of like small FTCs. They have what's colloquially known as small Section 5 authority for unfair and deceptive practices, but their jurisdiction is limited to their state. On the other hand, state attorney generals, knowing that their jurisdiction is limited to their state, often will band together and file a lawsuit with one lead attorney general, say from whatever state's most aggrieved, and then 19 or 20 others will join them. So I believe the Google privacy settlement that happened recently, I can't remember how many, but I think it was like 17 or 18 state attorney generals collectively sued Google. One was lead and the others were and they all were like, Google violated the law of Indiana and the law of Iowa and the law of California. And that's how they sort of magnify their authority beyond the states, and they engage in multi-jurisdictional litigation. The rest of the stuff, I'm not going to go too much into detail. I just want to have people awareness. There's always been state-specific consumer and consumer protection financial laws. There's tort law, contract law, property law, criminal and constitutional law, constitutional health privacy. As we all know, there's Roe v. Wade, which was in effect until about a year ago. And then some state constitutions have provisions that protect privacy. And the whole point of setting this out is to say that when there's no single overarching law to look at to, sometimes you got to look at the federal law, sometimes you got to look at the federal constitution, sometimes it's the state constitution. To the extent that and this will matter when we get to our block or preemption, there can be inconsistencies. And then one of the questions is going to be like, what controls or how do you work that out? Let's go to the next slide, because I want to make sure I get at least through all this. So now that's sort of a backdrop, and I know it's a lengthy backdrop, but I think it's important. So federal privacy legislation, a lot of questions I get when I meet international lawyers is, why don't you have federal privacy legislation? And the first is, I say, well, we do. It's sectorally divided, but we don't have what you're thinking of. But a lot of people in Congress are sympathetic to that cry. And so the American Data Privacy and Protection Act was introduced last year. This is one of the first federal privacy laws to actually get sort of significant traction and bipartisan support. It successfully passed out of its relevant House committee, I think 54-2 or 52-2, something like that, overwhelmingly passed through with bipartisan support. And then it ran into a wall in the United States Senate. And we'll talk about that wall later in a little bit, but it was a lot of people were really excited. They were like, this is happening. We wanted it to happen. The United States House is on board and we'll get the Senate later. And I was a little more skeptical because some of my background is interning I interned in the US Senate once upon a time, and the Senate is just different from the House. But so this law, there's some important concepts here I've devised these slides, by the way, as reference materials. So like there's more detail here than I'm going to talk about, but there's some elements of like what makes this new law interesting. There's some new stuff that some other laws don't have. There's some old stuff that's been updated, special rights for those under 17. That's sort of like inserting a COPPA principle. Algorithmic impact assessments is sort of like a direct take from the E-Government Act with privacy impact assessments. And then you've got your data minimization, which is an application of the FIPS, and duty of loyalty, which is something from the financial sector. It's quite interesting to see what they've grafted in from different strands. And you could do a whole separate presentation on like, what is the origin and where did all the elements of law for this particular piece of legislation come from? So it didn't pass. It may come back. Why not? So let's go to the next slide and I'll talk about the four blockers. So the four blockers: preemption, private right of action, dysfunctional Congress, and complexity. So I'll walk through each of these. And the first two are more legal and the last two are more situational. So the next slide, please. So preemption, we talked about, well, there's all these laws, which one would control, and we do have sort of a priority schema for that. And it's basically called the supremacy clause, which basically is federal law trumps state law. And so the Constitution says federal law is the supreme law of the land. And there is this concept, specifically legal concept of preemption. And it can have many flavors. You can have floor preemption, which means the federal government says you have to do this much. You can have ceiling preemption, which says the federal government says you may only do this much. And then you can have null preemption, where they say, we're not telling you what to do, but you can't tell anyone else what to do, whatever. So no one will know anything, and we just want nothing to happen on this topic. I've put a little explainer of these simple concepts. We don't need to go through that, but that's there as a resource for you guys later. Let's go to the next slide. Now, a more complicated version. So that was simple preemption. There is, in fact, like a more complicated take on preemption, which is, how does Congress exercise preemption? And it can exercise preemption either through express. It can say we are overriding it, and that's express, or it can be implied, which is they didn't say it, but you kind of figured it out based on the context. And implied preemption can sort of be either field or conflict preemption. Field is Congress has set the rules for the field in such a way that any state regulation would just be inconsistent with the way the federal government has set it up. Nuclear regulation safety, actually, for nuclear power plants is a good example of field preemption. Federal government thinks that's super important, doesn't want any state contradictions. It hasn't expressly displaced nuclear power laws at the state level, but no one bothers with it because it's so clear that the federal government safety standards have to be paramount in control. And so that's an example of field preemption. Another one is conflict. And this is the one I think that probably everyone was thinking of. And that's when a state and a federal law collide. They conflict with each other. And it's either impossible to achieve both the aspects of the goal of the law, or it poses an obstacle to federal laws. And I'm not going to go into resolving conflict preemption is itself a complicated legal topic, because it's not always like, sometimes maybe only part of the federal law would carry the day, or maybe all of it. But I don't need to go in all that. It's just this concept is important. Conflict preemption matters in a lot of ways. And I put another explainer here for you guys to click on later if you want to take the time to learn, to do a deeper dive. Switching to the next blocker, private right of action. And this is basically the idea that citizens can sue to enforce statutes. And America, as some of you may know, is a very litigious society. Some of us hate it. Some of us think it's amazing. And those of us who think it's amazing think this is great. The citizen can enforce their rights. And those of us who think it's terrible is like, that darn citizen, they are messing with the experts and making things really difficult and tying up judicial resources. And you'll see that I've sort of described that a little bit below. Democrats tend to believe in the power of the individual. They also this is less true now, but historically they used to get a lot of donations from the trial bar of attorneys who represent consumers. you can make a lot of money with private right of action if you in fact win. And so a lot of lawyers do in fact love it. And then private right of action tends to be opposed by Republicans on the idea that, you know, unnecessary lawsuits, supports this trial bar that really doesn't have any business like making money off like the legal system, frivolous litigation, doesn't support innovation, hurts small businesses, the whole 9 yards. Next slide, please. And so I've included some, if you want to follow in this, I've included some resources here. You've got a typical Democratic view from the New America, which is kind of a think tank. It's not expressly Democrat, but it's on the Dem side. You've got the Chamber of Commerce, also not expressly Republican, but it's on the Republican side. And you can read through it and you'll see like the things I was talking about when they say private right of action is essential, private right of action is terrible. And then I've included a semi more neutral thing, which describes the private right of actions in privacy law. I should say this has been written by a law school classmate of mine who's now worked down in Florida. And it's quite a good article, and I'd recommend anyone who wants a really deep dive to go into that. So before I turn to the next slide, one of the key things one of the key reasons the federal privacy law statute foundered was the Republicans didn't want a private right of action, and they didn't know what preemption. Actually, that's been the historical trend. That particular statute that I was talking about, the legislation, since it wasn't passed, the American Data Privacy and Protection Act, it actually included some limited preemption and some limited private right of action. They tried to like split the baby on those points. They didn't quite succeed, but it was an interesting approach. And that may be something that matters for us long term, in that maybe the solution is allowing limited private right of action and preemption. Now, it was very unclear which states got preempted and why. Like the BIPA law I mentioned earlier was not going to get preempted. California wasn't going to get preempted, but the other states were. And I think California was going to get preempted, and then California was not happy about it. So there was a lot of conflict because of like how those have been the two main sticking points. Then we shift to the third sticking point, and I don't know how closely you all follow US politics, but I put a little video in here. This is from October 3rd, and it's pretty short, so we can just run it, and then I'll keep going. And if we can run the video now.
Yeas are 216. The nays. On this vote, the yeas are 216. The nays are 210. The resolution is adopted. Without objection, the motion to reconsider is laid on the table. The office of Speaker of the House of the United States House of Representatives is hereby declared vacant.
Okay. So we can go back to the presentation. So, and I put this empty speaker chair. So this is, it's not historically unprecedented, but man, I think it last happened like 100 years ago or something. And we still don't have it's been like 17 days and we still don't have a speaker for the House, which basically functionally means the way they've set up their procedures, the House cannot function. They've got an interim pro tem speaker. He's got very limited authority under his own interpretation. And they're debating about whether they should like give him some more temporary authority, but it's not really been done because his authority comes from a law that was passed right after September 11th. So it's never been tested. It's more succession planning in case we have a disaster. So we're literally in uncharted waters here with this empty like House seat. And so the House is not functioning on a wide variety of things, let alone privacy. So this is sort of like almost too simplistic to say, but it's such a interesting time to be giving this presentation, to have the Speaker of the House, because I was just going to say, well, Congress is barely capable of getting anything done, and now I have a even better example. They can't even really get their own house in order. So I thought that was really interesting and important, and hopefully they're going to get themselves together and get a speaker. But if it's so much work to even get a speaker, you can see why we're not having a lot of traction on getting some important legislation passed if they can't even agree on who should lead them. Next slide, please. And then the other point that I wanted to mention, a lot about what I talked about, everything's complex. There's different state sectoral laws, there's different tort principles, there's federal law, there's preemption, there's regulatory uncertainty, there's this agency's interpretation of that. So it's kind of like, if you're going to make one federal privacy statute, what do you keep? What do you replace? Which bits worked well? Which bits didn't? Which agency is the right one? Which one's not? And what do you keep the common law principles? What about the case law development? So a big aspect of the resistance is to having the statute is there's complexity and there's also uncertainty. So there's I think it's FUD is the name, fear, doubt, fear, uncertainty, and doubt, which is like a term in the tech space. Industry is not, they don't love regulation, but they hate not knowing what they need to do even more. And so a lot of these industries that are regulated in the sectoral space are less interested in having like something that they don't understand regulating them. They'd rather either have the weak one that they know or the strong one they know. And so, and they it's also a bit of a gamble. Maybe they'll come out better, maybe they'll come out worse. And if you don't know what to do, maybe you sort of sit tight. So complexity, and I should have called this one complexity and uncertainty because it's really both. That's a fourth blocker. And then finally, I'm almost done, and then we'll have time for questions. Let's go to the next slide. So I wanted to add a bonus round here if I had time, and it looks like I have enough time to do this. So the other factor is it's not just our legislators and laws and actors and society, it's also the citizens get to play in the rough and tumble game of democracy. And so you have lobbyists for companies, and then you have citizens. Most regular citizens don't have time to like engage in this on a day-to-day basis. So their role has sort of been taken up by nonprofits. And disclosure, I worked for a privacy nonprofit the first year I was at a law school called EPIC, the Electronic Privacy Information Center. So, you know, for what it's worth, I feel a little bit more akin to the nonprofit side. But basically, when the first state privacy laws were coming out, I remember the lobbyists for a lot of industries that were going to be regulated were like, this is terrible. It's because there's a similar situation that occurred with data breach laws. We have approximately 47 or 48 different state data breach reporting obligations. And if you're a company that's in every US state, when you have a data breach and it affected data of the entirety of your consumer database, you have 48 different ways you've got to report it. Companies hate that. I would hate it. It's great for a lawyer, though, because they hire an outside counsel who sits down and says, here are all the ways you should report. I've done it for you, and that'll be $3,000, please. So when the privacy laws were coming along, and the idea was there was going to be first there was one, then there was two, and they were like, this is a nightmare. It's going to be terrible. The funny thing is, you don't hear that. I heard that a ton at meetings and stuff in like 2017, 2018, 2019. I don't hear it as much anymore. And this article that I've excerpted is part of why. A lot of the industries have gotten really engaged at the state lobbying level. And the states are actually easier to lobby because our state legislators are paid less. The legislatures are often part-time. And so they're just easier to get to. And so the quote that I have here is like, this is about the Virginia privacy rule, and take it for what it's worth. It's a political article. Like, you know, they're like, the first draft was written by an Amazon lobbyist, and then they were the model for everyone. States have different variations, but ultimately the tech industry is setting the stuff. And then you've got a quote from someone being like, man, this ain't right. Industry is influencing this. We're working off a model that's introduced by Amazon, which of course they hate. So this is another factor in this privacy landscape is you've got consumer advocates pushing for stronger privacy laws. Tech industry would not characterize themselves as pushing for weak laws. They'd say they're pushing for laws that enable business ingenuity and innovation to prosper and bring about the American dream. That's probably how they'd say it. So I wanted to add that in because I think that's an extra aside if we had time. And then we'll go to my last slide to sum up. With states like these, who needs a federal privacy law? We've been waiting for a federal privacy law for forever. Everyone said if we didn't have one, bad things would happen. And, you know, somehow we keep muddling through. It's kind of like waiting for Godot. And so the final emerging blocker is that as more states adopt their own privacy law, the question is, the supposition in question is like, maybe we don't even need a federal privacy law because the states are handling it. And I think a lot of the activity in, again, 2018, 2019 was like, we've got to get a federal privacy law before too many states do it and they'll hit a tipping point. I don't know if we've reached a tipping point yet, but we're at 12 states and there's 50. So we're coming up to the 25% mark. I'm pretty sure once we get half the states, it will be almost impossible to get a federal privacy law that displaces those regimes once they've had like the existing. Now, never say never. The Congress could always do it if they wanted, even if there were 50 states. But it just, every state that does their own thing is yet another actor who now values the status quo more than change. And as more actors do their own thing and value the status quo, the more the status quo is entrenched. Now, Congress has only itself to blame. Everyone's been begging them to act for forever, and they just haven't. So, like, there's that. But I wanted to close on that note, which is that the action at the state level is having a very important impact on whether or not a federal privacy law is needed or not. And with that, I think we can go to the next slide for questions. And I think I hit my time marks pretty well, and I'd be happy to hear from the audience. Thanks so much.
Well, thank you so much, David. For now, if you guys have questions, please let's answer. Is anybody there?
There seems to be a question in the chat, Jum. I can read it. So, David, can you please provide brief views of the Democrat and Republicans regarding Chamber of Commerce functions? The Republicans claim that the Chamber of Commerce prevents the small and medium companies to grow, thus it violated social justice. Thank you.
So the Chamber of Commerce was originally formed to sort of support businesses. It was a way, there's other entities, like there's a ton of these now, like the Business Roundtable and stuff, but the Chamber of Commerce is one of the oldest, and businesses and the Republicans have historically been aligned for quite some time, but particularly I think the Chamber was founded in the 30s. And so the Chamber is ostensibly nonpartisan and independent. And in the 70s and 80s, it was still giving quite heavily to sort of like kind of both sides, the Dems and the Republicans. That sort of shifted in the 80s. A lot of pro-business Democrats lost primaries or retired, and there started to be more of an anti-corporate vibe in the Democratic Party. And so the funding streams have shifted quite dramatically, so that now, well, I wouldn't say the Chamber doesn't donate to any Democrats. It's a much smaller minority. And the Chamber is interested in helping businesses prosper. And often the best way for a business to prosper is to have a low tax rate, because that increases its profits. So they advocate for low tax rates. They advocate for less regulation, because that often is easier for a business to run. And there's kind of, they're not reflexively anti-tax or anti-regulation per se, but they do tend to be aligned with the Republicans in terms of business interests, just because of where the Republican Party is now. Hopefully that answers your question.
Okay, the next question: will lack of U.S. federal privacy law affect ASEAN region like the Philippines?
The lack of a U.S. federal privacy law. I think it would mean that so it would depend, right? Because obviously a U.S. federal privacy law is going to govern the activities of companies domiciled in the U.S. Now, many U.S. companies that are in the U.S. are also kind of global corporations. And so to the extent that they had operations in the Philippines, a federal privacy law would affect how they would take care of their data. That said, often local subsidiaries of a company in a foreign jurisdiction, such as the Philippines, have to comply with the laws of the Philippines. So you can they would need to comply with whatever the local privacy law, if any, is, and the steps there. So I think the answer is mostly not a huge impact. More, it's unusual for the US, which is a leader in a lot of areas, to be completely like absent on this. But that my take is that I don't think it's a huge absence, other than a lack of inspiration. But I see Elizabeth raised her hand, so maybe she wants to add a thought on that.
No, I have a question. I'm here to receive information. but I'll leave it to Jim. So I don't want to interject if I'm in the queue.
Right now, there's no more question right now.
Okay.
Okay. Well, then,
You can be the one.
this is all really helpful, and for those listeners in the audience, I did pose a question in the chat and love to hear your reflections in the chat, or if you'd like to speak about, can the tension between, the states creating their own privacy legislation, can that almost act, and then the federal government's efforts to potentially create a federal privacy framework, could that almost act as like a microcosm for what we're seeing in Asia, where different Asian countries are creating their privacy laws? But I know in some of our previous discussions, we've talked about the need for a regional framework. Perhaps, David, even if the US can't be a leader or inspiration on the law, perhaps in the privacy or the policymaking realm, it could be if it gets a speaker, but that's neither here nor there. So, interested in everybody's thoughts online, put them in the chat or raise your hand. But David, I wanted to sort of shift gears. You've been talking a lot about sort of companies' obligations and the challenges that the tech companies are facing as a result of these myriad of laws. But if you have a client who's had their privacy rights violated by a large company that is presumably, it involves multiples of these jurisdictions in the United States. Again, we'll use it as a microcosm. Like, how does that complicate trying to actualize the rights or like actualize remedy for victims of privacy rights violations? So, if they're in one state, the company's in another state, the harm came from another state, like, how does that work? And do you have any recommendations for lawyers on strategies for addressing this issue? Thank you.
Yeah, so it's tricky. You often have to get lawyers from the local. So if you're in a particular state and you have a particular claim, what your rights are vary from state by state. Like in California, you may have more rights for particular redress depending on what it is. And in other states, you'd have less rights. So obviously, it affects very much what rights and remedies you have, and then it also affects your ability to effectuate those rights. One tool that I think a lot of people historically have utilized and that's been pretty effective is class actions. When class actions is where multiple individual claims are joined if they have the same underlying claim. So Google violated my privacy and your privacy and Bob's privacy, and instead of the three of us all suing Google individually, we get a class action. We get one lawyer, and those the lawyer sues on behalf of the class. And this actually is, in fact, how a lot of lawyers have overcome these challenges. The class action has to send out a law notice to the members of the class, informing them of it and giving them the right to opt out. And so actually what I have actually gotten as a personal citizen is I've gotten notices of class actions being filed on my behalf. They're like, did you use Zoom between this time and that time? Because Zoom allegedly violated privacy. And I was like, yes, I did. I will track that. And then they often settle because they often did something wrong. And class actions are very remunerative for lawyers because the lawyers often take like the whole pot, like the company settles for like, I don't know, 500 million. And the lawyer who brought the case, if they win it, they often get like 33% of it. So that's a lot of money for the lawyer. And then the remainder is distributed to the class. If there's enough people in the class, like for Facebook and Zoom, the amount you get is only like $5 or $6. But I will say I have been the recipient personally of multiple privacy class action lawsuits in the tunes of like 5 or 7. That Zoom one that I'm thinking of, actually, I got $33 from them. And all I had to do as a consumer to get my right validated was find out there was a class action, assert that I was a member of the class. They have a criteria. They say, did you use Zoom from this time to that time? I was like, yes, I did. And I filed a little claim. And then the class went through. And then when it settled or was resolved, I was told the action is settled or resolved. And if you'd like to claim your money, here it is. And that's actually been working fairly well. For other instances, so class actions is a great example of how to deal with the multiplicity of jurisdictions, the multiplicity of privacy right violations are often like death by 1,000 cuts. So like they're hard to see, and it's hard to get the energy to go after this big mammoth company to get it fixed. And so class action sort of bulks up the consumer side of the equation so that the consumers have better representation. You have to pay the lawyers quite a substantial incentive to make that even work, and that's why a lot of other people criticize class actions. They think lawyers get too much out of it, or they think the company is not paying enough. They're like, it's a rounding error for a company like Google to pay 300 million when they make 3 billion or whatever. But I think in a limited way, like class actions are still effective at getting companies to change their practices and still provide remuneration and psychic relief to the class. And I see some other questions were coming in from the chat, so we can switch to those. People starting to ask good questions.
There are two more. One from Sirilak: how to apply privacy law to the current situation of Palestinian Israel regarding uploaded on the internet to seek for help and was attacked because of their whereabouts shown from their devices. That's the first one.
Yeah, that's a tough situation, and that would be what the tech company, whatever tech. So it probably wasn't the internet; it was probably a particular platform or whatever run by a particular company, a tech company or whatever, and it would depend upon their policies and the jurisdiction they were under. There's actually not usually an obligation to keep location information like private, like per se, but it depends and varies upon jurisdiction. And so I am not familiar enough with like Palestinian and Israeli privacy law to effectively answer that. But I think a lot of it would depend upon the individual platform policies and the law in that case.
Just as a follow-up, David, to sort of broaden that out, because we do see in multiple jurisdictions the way that this location data can be used to weaponize against individuals. Have you seen examples of privacy legislation that walks that balance between like the need for that data to be transparent for some reason, and then individuals' privacies to prevent attack, which typically actually comes from the states in most jurisdictions, to add that.
So one interesting thing is the U.S. Supreme Court in 2016 in Carpenter held that cell phone location information that was protected, was constitutionally protected in a way that wasn't typically given to sort of location data. The information on your cell phone that tells people where you are we have something called the third party doctrine, which is where if you give a third party your information, you're deemed to sort of waived your privacy rights. And there's been a lot of critique of the third party doctrine, but it still exists in a lot of ways. But the Supreme Court in Carpenter heard this really interesting case where this man was basically arrested and tracked down using his cell phone location based on allegations of a crime and stuff like that. And he sued successfully, and the Supreme Court ruled the third-party doctrine didn't apply in that instance because the cell phone location was not something he really could voluntarily give because it was essential to the functioning of the cell phone. And so there is an emerging trend to sort of recognize location data has sort of a more special constitutional law status, at least in the U.S. since the Carpenter decision. But it is a bit limited in that, like, the police can still get it with a warrant or a subpoena, or not a subpoena, usually with a warrant. And then location data is definitely treated in some instances as sensitive PII. I know that I try to watch location data in particular because with location data, you can figure out a lot. The U.S. military discovered a couple years ago that its soldiers on secret commando bases in Afghanistan were giving away the location of the base by like letting things load up to their Fitbit, and they issued an order basically being like, no one is allowed to use Fitbits or these sort of devices. So there's different tensions about the fact that our devices are sort of tracking and broadcasting our location constantly. And I think there's a growing recognition that location data is more sensitive than some other types of data, as you can see, and you're starting to see it recognized at the constitutional level. I think several states I have identified location data as a sensitive item, and certain platforms are less aggressive about collecting location data now than they were, although it's very useful to do targeted advertising and what they call geofencing, so that the moment you walk by a mall and the moment you walk past the invisible geofence, they know you're there and they know what your phone's doing and they can target you with an advertisement. And that's fairly lucrative. So a lot of entities don't want to give that up if they can avoid it. So there is a tension, but because it's very useful, but it's very revealing. And I think also it lets people know where you are and they can hurt you. And so that's something that we're really starting to struggle with deep fakes and disinformation and stuff like that. And swatting. Swatting is this tactic in the US where you call the US SWAT team on someone. You say they're like the person is holding them hostage or something, and they show up, and then like the person is like, it's a very dangerous situation because the police are very heavily armed and they think something bad is happening. And so one of the things that people are trying to do is they're trying to protect location data so that people cannot be swatted. So I think this is a big point of tension that a lot of people are paying attention to. And I see more questions popping in, so I'll shift over to the next. And I don't know.
The question from Jennifer, data privacy is interconnected with cybersecurity. If there is no federal privacy law, how can the citizens protect their privacy online, especially when it is other people who violated it?
So again, my point would be that just because there's not a federal privacy law doesn't mean there's not privacy protections, and there's all that other stuff. And also, to make things even more complicated, we don't always address cybersecurity in the privacy laws. So like there are, like I mentioned, those data breach notification laws. Those are sort of after the fact cybersecurity. There's separate cybersecurity mandates. There's instructions on like breach notification. There was a rule that the SEC just passed requiring all companies to address cybersecurity. So cybersecurity and privacy are sort of the same side are different sides of the same coin. And you need cybersecurity in order to have privacy. Without the ability to encrypt data or to protect it, it's hard to actually get privacy. But I think the question here is, the absence of a federal privacy law does not mean you do not have cybersecurity protections. We, in fact, have several different statutes that address information security and several different company practices. And in fact, the US is way more robust on cybersecurity because there's like much more harm, obvious business harm associated with it than it is on privacy, because privacy is about human and citizen rights, and cyber is about protecting like intellectual property, businesses, business functioning and continuity. And so I think the answer to your question is that we protect it in different ways and with different actors, even beyond the privacy landscape.
Okay, I think Natasha Bergman, she's president of HRLA. She has a question as well. Would you like to speak, Natasha?
Okay, yes, I can. I'm sorry, but I cannot turn on my video. I hope this is okay. Thank you.
Yes, this would be great. I can hear you just fine.
Yeah, I tried to turn on the video, but it was not.
You.
Oh, okay.
You.
Yes. Hi, thank you so much, David. There's a lot of information to take in, and obviously we are moving at a different speed, almost as we are living in different universe. In Thailand, everything is also new, and the government not really consulting with us, and they don't respect our privacy at all. And then in making policy and passing the law, they always have this national security at a higher level than the people privacy, right? So they're collecting data and the surveillance, and then they use it against any pro-democracy movement or anything they say at their opponent to the government. I wonder if in the US policy, there is any way that in the US policy about privacy, in that can use to force, I don't know if you can use that as to force the government of Thailand to, moving forward, respecting people privacy in the way. In Thailand, I don't know if it's in the kind of international law where we have the treaty or the convention where we have to sign up, but between Thai and US, we are very little, right? We cannot go against you in just like China and the US, but in the way when US said, okay, this is what we give priority to, and we wonder if you're going to do anything like that to protect your people, would that
Yeah.
even be in, I don't know, do you
No,
have
no.
any idea?
So I think one of the aspects of the US that matters a great deal is soft power, which is the site and an example of as inspiration. And I think while there's not necessarily going to be a specific legal mechanism that would encourage the Thai government to be more respectful, I think the US used to have a much more aggressive national security apparatus that was less respectful of people's privacy. And when the Snowden leaks happened, people didn't like it and people responded to it. And that tension so I actually graduated around that time from law school, and I've watched how privacy has become a lot more important. The US government has started to put more focus on it. And you've started to, and particularly even in the national security context, there's more of a emphasis on balancing it now, as opposed to sort of just like national security wins all the time. And in fact, the brand new US EU privacy framework that was just negotiated was negotiated precisely to grant the Europeans new privacy rights vis-a-vis the national security apparatus of the United States. And so they set up a special appeal process. EU citizens who normally don't have access to any US process now have the ability to sort of say, hey, I think my data was misused by the United States government or something like that in the surveillance or whatever, and they can appeal, and it will go to the Office of the Director of National Intelligence. And then there is a additional layer of appeal at the Department of Justice where they will like review this. It's very secret and intense, and so there's not necessarily a lot of information coming back out, but it is a process. The President Biden issued an executive order to set it up, and it's actually really important. I actually know the attorney who is helping the court. Like, it is not just we think this is important. We're putting like real money and people into like complying with this agreement. And I know that doesn't help you so much with what you're struggling with, but I do think there is this example. The US has already, just in the last decade, has shifted from hey, the national security needs are fairly paramount and US privacy needs are going to have to give way, to much more about a balancing. And I think in your case, the argument could be that, we need to follow an approach where we balance national security, like the US, like the European Union. This is where the world is going, except for China. And you don't want to be China. So
yeah, like a lot of people in Thailand, they just, maybe because TikTok have a lot of influence, and then they're leaning towards China practices. They said the government need to be strong because they have to control people. This is very scary. And then I just, the government from the last election, they also understand how the social media can affect the outcome of the election. So I feel that in the next election, they already have something up their sleeve of how they're going to control the population. It's very crazy. But anyway, thank you so much for your lecture. It's very informative.
Yeah. And I know that I think Elizabeth might be a better one to speak. I mean, the project that she's working on, the Defending Digital Privacy, has State Department grants. And so the State Department is interested in facilitating sort of these communications in other countries. And I think Elizabeth might have something to say about that. But I think that is another way, the idea that encrypted messaging platforms, there's a growing it used to be the US government thought encryption was terrible and we shouldn't allow anyone to have it, and we've now come a long way to like allowing and understanding that encryption protects important rights of dissent and communication. And I think that's another avenue. There are US tech platforms that provide end-to-end encryption that I think are still available in Thailand, although they maybe are cracking down on some of them, like Signal and WhatsApp and stuff.
Yeah, I think there is nothing safe. We have been moving from app to app, trying to find the safest app that we can talk, but there seem, every 6 months, there's some news coming out of how the government get the information from the chat. And then we just have to continue moving. I think if the government would respect us, it would be easier. We don't have to find anywhere. If some big brother like the US will say, "Hey, listen, this is the," I just hope.
Right. This is not the best example. I hear you.
Yeah. Thank you.
Or thanks.
Okay, okay, thank you, Natalie. For the next one is the question or is suggestion. Okay, it would be interesting for the case that hotel usually say that they cannot share any of personal information of the hotel's clients, and the practice cannot be applied to platform companies. So it's kind of conversation, it's not a question.
Okay. Thanks for the comment. Yes.
Thank you. And the next one, can you discuss the issue about the need to protect tribe privacy with the First Amendment? What is that?
Yeah, I'm not quite sure I understand the question here. I mean, child privacy is mostly like on a statutory. Are you saying? I guess maybe I'm not understanding the tension here.
Okay, so
I think I know we're coming up on time, but I think what they're trying to ask is like the First Amendment being freedom of speech versus protecting children's privacy. So like, how do you make that balance between freedom of speech and then different vulnerable communities' privacy?
Yeah, and I think what's basically happening is a lot of the tech platforms are sort of just establishing age limits and digital identity verification and saying they used to just say, click here, tell us you're not 13, we trust you. And lately, a lot of legislators have been saying that's insufficient. You need to actually make sure that you're not like doing this stuff to 13-year-olds and tolerating it. And so I don't think there's much attention with the First Amendment because the First Amendment applies to government entities and a lot of these companies are private. So there's not actually a First Amendment right to be implicated here. I think the underlying question is more like, what about the rights of children to speak on platforms as opposed to getting blocked by age? And I think the answer to that is, children have less rights in society until they reach the age of majority. We don't let them smoke or drink or drive cars. And so maybe getting on TikTok and Twitter is similarly becoming something that's not ready for prime time till they're older. Now, just like enforcing smoking, drinking, and driving car prohibitions is tough on 16-year-olds, they sneak around. They're probably going to sneak around to get on these platforms. But I don't think there's an actual real First Amendment issue here. It's more about what right do children have to partake and participate in our technology community. In a lot of ways, though, the studies have shown that it can be very damaging for brains that are forming. And so I think there's a lot of good reasons for children to have less access to platforms. There's a lot of cyberbullying. There's a lot of negative attributes. So there's a healthy discussion to be had about it. But again, I don't think it encompasses the First Amendment in this way.
Okay, I think we almost ran out of time. I think we do it in 1 hour sharp, and many people now say thank you to you. No more question. And the last one from Mayete or Majet. I'm sorry if I call your name incorrectly. Thank you, Mr. David Husband. Your discussion about the U.S. Chamber of Commerce concern for small and medium businesses is sincere. I have read the U.S. Chamber of Commerce article regarding what should not be included. National Privacy Bill through the Chamber of Commerce prioritize small and medium business economies capacity. Okay, just
great. Thanks for that comment.
Well, I any more questions? The last one perhaps, and then I think is about perhaps time to finish this virtual seminar. Is no more question? The last one?
Well,
Okay, no more. Okay, well, I would like to say thank you so much, David, for your input, from your knowledge. I hope that all the participants can learn from the US in terms of the literature and everything. It's different states, different places have different. Hello, can you hear me? Is something wrong with my Zoom?
Yes.
Okay.
No, I can hear you.
Yes, it's different category, different legislation and everything. But anyway, in Asia, we can learn from US as well. And in Thailand, we just has a PDPA Act just been enforced last year. So it's kind of different level, different complexity as well. And also thank you so much for the participants from Asia, from 4 countries. I appreciate your input and your question. And this one make us feel like, okay, we need to create more virtual seminar for you all. Please let us know if you have something that you would like to learn more. We will engage with ABA Rotary, and even you, if you need someone to be a speaker or yourself want to be a speaker, let me know, just email us directly. And yes, thank you very much. And thank you, Elizabeth, again. It's very early for you there.
It's no worries. Thank you, Jim, and thank you everyone for joining. I hope you have a lovely evening, and David, you have a lovely day.
Thank you. Thank you so much for having me. I was glad to be able to chat, and I hope you found my presentation helpful.
Yes, and we also will share the presentation via email to every audience here, and also we'll post on our webpage of HRLA. Thank you very much, everyone. Have a good evening and have a good day.
Thank you, everyone.
Thank you.